Hello everyone, we are indeed privileged and honored to host one of the constitutional experts in India and one of the constitutional experts in the world. So we are hosting Professor Pratap Bhanu Mehta. He is the CEO and the chairman of Center for Policy Research in New Delhi. So thank you very much, Professor, for joining us for today's discussion, and we are indeed privileged to host you. Just to ask a couple of questions from you on behalf of Adocata. Sri Lanka is in a crossroad of coming up with a new constitution, and there are new economic revamping program is about to launch. So how do you see, especially when coming up with a new constitution, what are the things that a government should follow, and do you think Sri Lankan government is adhering to the process of coming up with a new constitution?
Look, I can't speak specifically about the Sri Lankan politics, but I think some general principles, right? I think one has to bear in mind. I mean, as I did say yesterday, I think constitutions are social contracts between a specific group of people, and ultimately they have to decide what's legitimate or not legitimate. I think the first question is, what are your aspirations as a society in terms of the values you want to embody? Is your constitution a constitution of hope or a constitution of fear? By constitution, I mean a constitution that actually trusts the people and says to them, if we give you the liberties, we will actually have a more creative, dynamic, vibrant society, than as opposed to a constitution which says we constantly need to create a paternalistic state to take the people's decisions for them, right? And my own sense is, I mean, this is a bet I think we should take in South Asia, that if you trust the people, they will rise to the occasion. But if you concentrate more and more power in the state at the expense of the liberties of the people, right, you will actually, squelch their dynamism and their creativity. So that's a first kind of philosophical decision, right? The second decision is, in a sense, I think, asking the question, what will meet the legitimation demands of the people, right? A just and legitimate constitution is one where everybody living under the constitution says, yes, this reflects our aspirations, or it allows us the kind of space we want. It's an inclusive constitution, right? And now, what specific institutional design makes it inclusive? There can be some disagreement over that. There are different models. I mean, even if you take something like federalism, there are 7 or 8 different models in the world. But the test they need to pass, whichever model you choose, in fact, I think it's less important which model you choose. The test it needs to pass is, it has to assure most people, right, as individuals, right, that their rights are going to be protected, they're not going to be targeted for who they are, right, and it provides a architecture for inclusive sort of governance, right. I think that's the third and final thing, which is a bit more difficult, is institutional choices. Constitutions not only set norms and goals, they lay down principles, but they make specific institutional choices. Which function should be performed at what level of government, right? We all want independent judiciaries, right? But what should be the scope of judicial power? How do we understand the separation of powers? I think the choice of institutional mechanisms can sometimes be enriched by a deeper consideration of comparative experience, right? Where often I think it's a mistake to say that, because institutions are dynamic things, they evolve over time. And so one of the things you have to try and figure out is, what is the likely direction of an evolution of an institution if you design it in one way rather than the other? And that debate has to be a kind of sober and reasoned debate.
Okay. Professor, could you also kindly explain a little bit about the concept of absolute guarantees of equality and why it is important, or what are your thoughts on that?
So look, the absolute guarantees of, equality is a very complicated concept, right? But the baseline concept which every liberal democratic constitution has to adhere to is something like a non-discrimination principle, right? Which is nobody will be excluded from exercising their rights as citizens, right? Just because of who they are, their religion, ethnicity, sexual orientation, and so forth. Right? That's the very baseline formal norm of non-discrimination. Now, things above that get a bit more complicated, right? Because technically, our promise to our peoples, and that's part of every social contract, that this will be a society founded around equal opportunity, right? Not equality of outcomes, but equal opportunity, although there's a complicated relationship between the two. Creating the conditions for equal opportunity has turned out to be much more complicated than we realized, and in fact, inequality is actually growing sort of globally, at least intra-country, inequality, which also poses political risks for constitutions, right? So, the interesting question to ask is, how do you create the conditions under which individuals and people have the basic tools and resources to be able to participate in a growing economy? That's the context in which health, education, some basic safety, some would argue some minimum social welfare provision actually become important. These should not be seen just as social spending. They are actually the minimum conditions that allow you to participate in an economy. Just like free speech is an enabling condition for you to be able to participate in a democracy, right? A minimum degree of lack of morbidity and education is a minimum condition for you to be able to participate in this economy, right? So now, what is the threshold of that conditions, how high that should be? That is of course subject to democratic negotiation, but there is no escaping the fact that you have to make provision for that, right? Then there's the tricky question, which is where the most disagreements, I don't think people disagree at this level, to be honest, I think there's broad agreement, right, is what's the institutional architecture that delivers this? Is it public provisioning or private provisioning, right? Often the way the debate is constructed in South Asia, there's a sense among some people that private provisioning is more efficient, but it's more inequitable, right? Because you have to, in a sense, pay, in a sense, to access it. Many argue that public provisioning is actually very important because otherwise you simply reproduce the inequalities in society. And one of the interesting challenges in education, for example, is every society used to say that education is the site where inequalities are mitigated, right? No matter what your background, you will get an equal opportunity education. Once you're educated, you can compete equally with others. But what we are finding globally world over is that education is the site where those inequalities are actually being reproduced. The rich can have private tuitions, they can go to institutions abroad, they can take an exit option. But if the public schools are failing, right, then you're shortchanging the poor even if you've actually given them basic access, right? So, and as I said, there are different models, those depend on the circumstances you're in. But we have to be honest about whether our institutional architectures are achieving those goals.
Okay. Also, Professor, Sri Lanka, I know we talked about this topic in depth on our public lecture on incorporating socioeconomic rights in the Constitution. What are your thoughts and what would be your advice for the Sri Lankan people and for the Sri Lankan government when incorporating socioeconomic rights?
So let's say a couple of things. First, these rights are instruments to something, and the goals that they embody should be relatively non-controversial. Nobody should contest the fact that you need a good public health system and access to healthcare or to education. I mean, I don't think that's a topic of dispute, right? And I don't think it's a distinction that cuts across left and right. I mean, both can be committed to that. My submission in that lecture was the following, which is that you certainly need the state to create the conditions to bring about these rights. My own preference is that it be done through the normal processes of representative politics, through normal legislation and administrative and policy means, rather than through constitutionalization. And I say this for two reasons. First of all, you cannot have a functioning democracy if more and more things are depoliticized and taken out of the ambit of legislative competence and executive authority, right? Second, the political process is designed to resolve disagreements, right, and produce compromises. We think compromise is a bad word, but how else do you produce social policy in a sphere of, disagreement, right? And third, these are areas where you need policy processes where there is some democratic experimentalism and iterative learning, right? Constitutionalizing them risks giving courts more powers than they should have. Number two, the downside of giving courts more power is that courts usually don't have enforcement powers anyway. So you can end up in this odd situation that India did, for example, where the courts have promulgated a whole series of rights, but are not in a position to create the remedies for them. And in South Asia, we are very used to thinking that courts can be a substitute for executives and legislatures, and rights can be a substitute for intelligent policy making. And my argument was that they are not substitutes. Even if you delegate these powers to the court via the enactment of constitutional rights, ultimately you will have to fix your bureaucracies. You will have to fix the legislative process. And if you fix them, you don't need the courts. And if you don't fix them, the courts are not going to be effective anyway.
Okay. Also, Professor, in terms of the South African Constitution, which is one of the progressive constitution on socio-economic rights and development, could you kindly share what's the case study there, what are the developments that they have gone through, and what are the constraints that they have?
The South African Constitution was a very radical and innovative constitution in incorporating all kinds of social and economic rights. And partly it was understandable because of the legacy of apartheid, right, where a tiny minority had excluded the population from pretty much every kind of social welfare provision, right? Housing, segregation, right to walk on streets, so on and so forth. So it was considered a very progressive constitution, and in the early years post-apartheid, it also produced some very innovative judgments. There's a very famous case on Grootboom, which is really about the right to housing, which many people across the world thought was a model about how courts could actually intervene to create, good social policy outcomes without treading too much on the domain of the executive, right? Essentially what the courts did, they were subjecting the government to a test of reasonableness. So they're not saying we'll tell you how much to spend, we'll tell you, how to design policy. What we will say is that if you say that the stated aim of a policy is housing for poor, does the policy you enact stand in reasonable relationship to that outcome, right? So there was some optimism that the courts could enforce some accountability. But South Africa is an instructive case. As the political system has deteriorated, right, post Mandela and so forth, you actually find the quality of the judiciary deteriorating as well, right? A lot depends on what the nature and character of your judiciary is, right? Usually states that have a governance crisis, that governance crisis also ends up getting reflected in the quality of the judiciary, right? So now all the promises of those rights in those constitutions, actually the courts are not being able to fulfill. Either they are abdicating to the legislature, or they are producing judgments that are not as powerful and as reasoned as the judgments were in the early courts. And it's an illustrative example that courts cannot save liberal democracies from themselves. If there is a serious crisis, at the margins they can work. They can work on protecting civil rights at the margins. They can work on, as I said, deepening a conversation on accountability, right? but courts are not going to produce those social outcomes that you want. And the sad truth is, South Africa still remains an enormously segregated society, right?
One final question, Professor. Countries like Sri Lanka and India, there's always the norm or the perception that the politicians are not capable enough to deliver the needs of people. So people also tend to think that the courts, the judiciary system is capable of doing it through court orders. But you had a good argument how when the court try to enforce certain things, how the court becomes also politicized. Could you kindly explain your views on that?
So there are two things, right? One, I think, look, I think it's a given fact that in any society, most institutions will reflect the ethos of that society. So if bureaucracies and politicians become corrupt, judges will also become corrupt at some point. And in India, for example, there is a big debate. I mean, there is a serious debate on judicial corruption as well. So this idea that you can protect some institutions from a general social, political, cultural ethos, I think that's a bit of an illusion. The same pathologies will get reproduced. Number two, corruption is also a function of power, and if you give untrammeled power to judiciaries, near absolute powers as they've acquired in India, you get two forms of corruption. One is what we normally think of as corruption, which is bribes and so forth. That's one small part of the story. That's not the real part of the story is that you forget to ask the basic question: what is my core function, right? The Indian judiciary has been, it's a mixed record. I wish it had been stronger in protecting civil liberties and human rights and freedom of expression. I wish its records on its core functions were stronger than its record on, let's say, social and economic rights, which it kind of promulgates. Third most important thing to remember is a judiciary has no delivery mechanism. The only delivery mechanism it has is to basically pass an order. If the government doesn't obey, it can pass a contempt order. And most contempt orders do not come with sufficiently big penalties. I mean, what is the judge going to do if a legislature and executive decides it's not going to follow a court's order? And it's easier not to follow them the more complicated matters are, right? And often judiciaries risk backlash if they actually overreach, right? So I think it is more important. We often joke in India that every branch of government is trying to do every other branch of government's work other than its own. Okay. Judiciary is trying to make policy, the government is trying to usurp adjudicatory powers, right? And that's not a very happy situation.
Okay. Thank you very much, Professor Mehta, for joining us, and we are indeed privileged to host you, and thank you so much for joining with us. And so we look forward to see you in our next Adocata interview.